Good morning, everybody. My name is Shelby Sargo. I'm the Supervisor of Registration Renewals here at the college. Thank you so much for joining us for this educational session today. Key considerations around health information custodians in diverse practice settings, presented by Kate Dewhurst. Before I introduce Kate, I'll go over a few housekeeping items. This session has live captions. To turn on the captions, you'll click the Show Captions button just below the video player. You can choose to see the live captions in either English or French. If you need tech support, please use the tech support chat at the bottom left-hand corner of your screen. Click on the icon and you'll be connected with our live support. There will be an opportunity to ask questions at the end of the session. You can submit your questions through the chat feature on the right-hand side of the session page on the virtual portal. Now, let's begin today's educational session. I am very pleased to introduce to you all Kate Dewhurst. Kate is a health lawyer with a focus on privacy. She works with social workers and social service workers through their workplaces in school boards, hospitals, family health teams, and community health centers. Kate was involved in the rollout of privacy legislation in 2021 for children's aid societies and Indigenous child well-being agencies. She was in-house counsel to the Center for Addiction and Mental Health for 5 years in the early 2000s and now heads her own law firm and training company where her mission is building a trustworthy health system. Please join me in welcoming Kate.
Thank you so much. Okay, here we go. We're going to talk about privacy. I know you're all excited. So, to start off, I'm a lawyer. I have to tell you this. This is not legal advice. This is for general information purposes only, but I do hope to answer your questions, so please add them into the chat because we do want this to be interactive at the end. I am going to share with you 6 topics on privacy. I want to give you the background of why you might find the law to be complex in your environment, because there are many different pieces of legislation that impact social workers and social service workers when it comes to privacy. I also then want to share with you, what do you actually have to do if you are a health information custodian, if you run your own social work practice, for example. You may have to fulfill the obligations of a health information custodian. I want to give you concrete steps that you need to take to make that a reality. Then I want to talk about the circle of care. We hear about it all the time. It is a mysterious thing. There is lots of misunderstanding. So we're going to get to talk about that, what you can share, and with whom. The ever-favorite topic of privacy and children, and what can be shared when you have 2 dueling parents who want to have access to records, who want to share information with you but not with the other. And how do we enable children to make decisions for themselves, feel that autonomy of choice, but also create a context around them so that they have support of their family. The 5th topic, we will talk about the limits to confidentiality, and this will help you to phrase out that introductory conversation with clients about what are the constraints that you have for sharing information. When do you have to override privacy? In what context? What will you have to share? And then the final topic will be privacy breach identification. And I want to explain to you what is a privacy breach so that you can come forward, whether it's in your workplace or in your own practice, to fulfill the obligations of notifying clients if there has been a privacy breach, and in some circumstances, sharing that information with the Privacy Commissioner of Ontario. So lots to do today. Let's start off with that first, setting the context. What are the laws? What do you need to know? And this will depend on your work context. So we have 9 laws that can apply depending on where you work. So those of you who are in the Children's Aid Society, Indigenous Child Wellbeing Agency space, you need to know about the Child, Youth and Family Services Act. Others of you will work in other kinds of youth centers and services. You also need to know about the CYFSA. Part 10 came out in 2020 and got implemented in 2021. So we have a rather new set of rules in that Children's Aid Society context for privacy. We didn't have set out privacy rules until then. So that's fairly new and people are kind of getting their heads around that space. What we're going to focus on today is the Personal Health Information Protection Act. So that is going to apply to all of you who work in the healthcare space, whether you have your own practice or whether you work in a hospital, a family health team, a community health center, a mental health agency, anything to do with seniors healthcare or youth healthcare. You're going to be subject to the Personal Health Information Protection Act. That is where we're going to focus our attention today. But you also may be subject to freedom of information laws, and those laws apply to government entities. So if you work in a school board or for public health, if you work for government, those agencies are required to follow freedom of information rules. Now, for the most part, they're the same as what we are going to be talking about under the Personal Health Information Protection Act, but there can be an added layer of transparency when you are working for one of these government institutions. The Education Act, again, if you're working for a school board, there are some exceptions to the right of privacy if you are working in a school board, so that may apply. If you have questions at the end, I'm happy to answer questions about that. If you're working in a public hospital, there are rules under the Public Hospitals Act and under the Mental Health Act. For any of you who are working in a psychiatric facility, any of my colleagues from the Center for Addiction and Mental Health, you are subject to the Mental Health Act. There are privacy rules baked into that. And then any of you who intersect with the criminal justice system, we do have to take into account the rules that come under the Criminal Code and the Youth Criminal Justice Act from time to time. So all that to say, depending on where you work, you may have a slightly different context. So what I want you to take from that is you need to know, if you have your own practice, all the laws that apply to you. If you work in an environment where you're an employee, your employer will let you know, here is our legal context. So your employer will be responsible to tell you what laws apply and how to follow those rules. So our attention today is on the Personal Health Information Protection Act and the health context that social workers and social service workers perform. But what I also want to share with you, for any of you who aren't in the healthcare field, you can still pay attention because it's all the same. So to be a trustworthy social worker and social service worker, you have to protect privacy. To be someone who other people are going to share their most intimate thoughts and worries and concerns, you have to be someone that they will come to and trust that you will keep their confidences and that you understand how to share information when necessary, how to keep confidences when necessary, and how to give access to records to your clients. So no matter where you are, no matter what rules apply, the ethical principles that underpin all these laws are identical. So it doesn't really matter. There is a little bit of tweaking around the edges under the Child, Youth and Family Services Act for children's aid societies because there is an additional layer of child protection that can override privacy. In the healthcare context, there is a little bit of twinkling around the edges because of the circle of care. I do want to talk to you about how social workers and social service workers are in the circle of care. You can assume implied consent to share information within the healthcare system. That is slightly different than other places where you may work. So that was really, what's the legal framework? Now I want to get into the details if you are a health information custodian. So what is this term, health information custodian or HIC? It is a term that comes from the Personal Health Information Protection Act. And might I add, this is not an opt-in model. So I teach a lot. I interact with a lot of service providers around the edges of healthcare. And I hear from time to time, for example, police officers who want to be in the circle of care. They want health information shared with them because it would benefit their investigations. But you can't just opt in to being a health information custodian. You must be listed in the legislation. So let's find out who is listed and how do you fall into that list or where. So when we look at this list of who can be or who is a health information custodian, Social workers and social service workers can fall under a variety of places. So you're different than other kinds of providers in lots of ways because you can kind of populate in different environments. So when you look at the list, you will notice it's all the usual suspects of organizations and individuals that deliver traditional healthcare services. When we think of the tiny box of healthcare, these are the people who deliver that traditional sense of healthcare. So pharmacies and labs and hospitals, and we have also long-term care homes. But for you, you get counted if you are in practice by yourself or with colleagues. You are counted as a healthcare practitioner in many circumstances. I will explain that in a second. But also where you pop up is when you work for a community health center, a community mental health center, or a community health or mental health program or service. If you have questions, for example, a shelter, a youth shelter serving people experiencing homelessness, is not normally a health information custodian. But when there is a social worker and a nurse and a physician who work within a shelter, they can be a health information custodian group within a non-health information custodian shelter. So if you have any questions about that, please do put that into the chat. It doesn't have to be that your whole organization is a custodian. You can have a small group. So that also applies, for example, to school boards. School boards themselves, not health information custodians, but the healthcare providers within a school board are a group of healthcare practitioners. Therefore, all the rules of health privacy apply to all the records and all the interactions that happen within that professional service team. So you may also pop up under a community health center or a family health team, or you might work for a hospital or other place. But if you do have any questions, please do put those in the chat. So you pop up as healthcare practitioners, in quotes, because under the legislation, it defines healthcare practitioners as anyone who's a regulated health professional under the Regulated Health Professions Act. But that's not you. You are found in the next bullet. So all social workers and social service workers who are members of this college are healthcare practitioners if you provide healthcare. So then we have to stay tuned. What is this healthcare? So because not all social workers provide healthcare. Then another group that are also captured as healthcare practitioners are anyone else, even if they're unregulated, if their primary function is to provide healthcare and for payment. So this does not include volunteers. Anybody who's providing, quote, healthcare, and I'll define that in a second, for payment is also a healthcare practitioner. So you may be working alongside other people who aren't regulated, but who are providing healthcare, and they are still healthcare practitioners and therefore health information custodians for their documentation. So what is this healthcare thing? Now, many of us think we know what healthcare is, but it is defined in the Act. And so if you are a social worker providing healthcare, then you are doing observations, examinations, assessments. You're providing care or service or procedures that are done for health-related purposes and that are provided or carried out. Now, I know we don't diagnose in this college, but to treat or maintain an individual's physical or mental condition. So that's a lot of work that social workers and social services workers do, is in that maintenance or treatment of mental conditions. It also includes preventing disease or injury. And also, if you are working in the palliative care space, it's service in that palliative care space. It does include home and community care services, and then it also includes compounding and selling devices, which is likely not to apply to you. So, what's our bottom line? The Personal Health Information Protection Act does not apply to all of you. So you do have to exercise some judgment as to whether your business is captured by the Act. You do have to be providing health care. And so if you're not, then the Personal Health Information Protection Act does not apply. So those of you who are working for children's aid societies, Generally speaking, you are not subject to PHIPAA. You are subject to the Child, Youth, and Family Services Act and Part 10. And as I mentioned, same, almost identical rules. Now, if you're working in the prison system or for parole or for courts, you're generally not providing health care. Now, there are some services, and this also would apply in children's aid societies. There are some health teams within a children's aid society. There are health teams within a prison. It is possible that you're delivering health care, but you would need to differentiate that for yourself. If you're doing work for Ontario Works or ODSP, then also that is not for health care. Although the determinants of health, like transportation, education, income support, all contribute to someone's health condition and outcome, those services are not health care for the purposes of this legislation. The idea is that we're capturing people's interaction with their healthcare providers are sacred and special, and we want to have special rules. So who's not a custodian? Universities, teachers, school boards, not. But again, social workers, on-site medical clinics, psychologists, speech-language pathologists, your colleagues who are occupational therapists or physiotherapists or audiologists, they will all be health information custodians in a team within the school board. Shelters, not custodians. Landlords are not custodians, except you may be working in a supportive housing team. And it is possible that there is a subset of service workers that are supporting people in their health journey, many times for mental health recipients. They can be health information custodians even within a landlord kind of context. Municipalities are not health information custodians, but they often do run health programs, and those health programs are custodians. And then, as you will see on the right-hand side, all the other people that you interact with, like children's aid, not custodians, police officers, probation officers, prayer leaders, spiritual healers, food banks, Workplace Safety and Insurance Board, Ontario Works, ODSP, income support, tax support, transportation services, immigration, insurance companies, employers, animal welfare, not health information custodians. That doesn't mean we don't share information with them. It's just when we get to that part on circle of care, we can't assume that our clients want us to share information with them. So when we're dealing with these authorities, for the most part, we would need express consent. So I'll explain that in a minute. So your question to yourself is, are you a health information custodian yourself, or are you an agent? This is an important question for you to be able to answer. Let me help you do that. So if you're employed at a school board, at a family health team, at a community health center, or at a hospital, you're likely an agent. And that means your employer is the custodian and you follow your employer's privacy rules. They will set the policies, they will give you training, they will have you sign confidentiality agreements. They are responsible to set the rules and answer questions of clients and deal with any kind of compliance issues with the law. But if you have your own practice, you are your own health information custodian. If you work in a group, then you, with your other group participants, have to decide, are you acting individually as custodians, or are you going to act as a collective? Acting as a collective, as a group, is normally the default if you have a corporate entity. So if you, as a group, act under a corporate name, then you are generally working as a group. The corporation is the custodian, that you may own that company. If you have a partnership relationship with others, then you are generally operating as a group. Sometimes, however, you're just sharing space. So you might be working in a wellness center, you may have your own practice, you keep your own notes. Really, things aren't totally integrated. Most of that time, you will be your own custodian. And so each person who's providing services within that wellness center umbrella, you might be your own custodian. This is something you should know. So if you're sitting there thinking, I've never thought about this, this is something you should put your mind to. This is something that you do need to differentiate. So what would you do? Let me share some ideas with you. If you're in a group practice and you've never put anything in writing, I'm going to prompt you to put things in writing. Does it have to be in a contract? No. It can just be put into a document where you share with your co-space sharing humans. What are we doing here? Are we doing things together? Or are we doing things independently? And that's a good idea for all kinds of other legal reasons. But for privacy, the Information and Privacy Commissioner of Ontario has come up against some of these group practices where all of the participants had no idea whether they were custodians individually or collectively, and then at the point of a breach started to point in the other direction. Not me, I wasn't supposed to do anything. The Privacy Commissioner does not like that. We do want to have certainty, and also your clients don't like that. They don't want you pointing at someone else. I'm not supposed to have done anything to protect your information. That was someone else. Your clients want you to have certainty. Are you responsible or is someone else responsible? So putting something in writing, even if it's just a letter to each other, here's how we work together, is good enough. If you want to have a document that is a contract, great. But you can, as long as you kind of think through these issues, you're a long way into compliance. So you want to put in writing if each person is their own custodian, or there's a corporate custodian, or are you acting as a group or a partnership? Who is your privacy contact person? In a minute, I'm going to share 13 responsibilities of a custodian. The contact person is really the one who is responsible to ensure everybody understands what compliance means and they are answering people's questions and dealing with the privacy commissioner if that becomes necessary. So you want someone who's going to stand forward and take responsibility to be kind of the voice of privacy within the organization or within the group. You also want to know, do you have your own privacy policies? Are you sharing those? Who is doing audits? If you have an electronic system where you document, who is making sure that if it's a shared system, there isn't anybody going into that system who shouldn't be going into that system? Who's doing the safeguards, the physical, the technical, the administrative safeguards for the practice? Who's reporting to the privacy commissioner if that becomes necessary? Another thing, and I know this becomes an issue for social workers and social service workers, is who responds when a client would like a copy of their own record. And just by the way, as a reminder, the client owns their information. You own your physical document, the electronic system or the hard copy. You own that, but the information belongs to the client. So there is a, 40-year standard of giving access to records for clients, but that was solidified in our legislation back in 2004. So clients do have a right of access. So who responds when a client wants a copy of their record? Who will make a change or look at the record if a client wants to correct their record? What if something's wrong? Who will look at the record and decide, okay, yeah, we'll change that. That was incorrect or not. And then, excuse me, as you know, you'll get tons of third-party requests. These might come from insurance companies, the police. It might come from a court. Who's going to respond to those in this group practice? What's the consequence if someone in this group practice, especially if you're sharing an electronic environment, what if someone goes rogue and they start looking at other people's records? What's the consequence? Are you going to kick them out of the electronic system? Are you going to kick them out of the group? What will be the response to that? And I know that you may not want to have to talk about that in advance, but it is really important that you do so, because when you have a situation where someone has committed a crime, when someone has committed a very serious privacy breach, you want there to be clarity in your rules that they have to go, because no one is going to want to leave the shared environment when they are being investigated for something difficult. So you do want to have a way out of those relationships that makes it a bit easier for the rest of you. What happens when one of you leaves? Do the records stay? How long do they stay? Do they meet the college guidelines for retention? Do the records have to go with the person who is leaving the practice? What if you have been commingling your documentation? Do the rest of the people get to keep a copy? Does the person who's leaving have to give you access after they leave to the copy that they take with them? So these are things you want to work out. Who has leverage? Sometimes when you're in a group, you'll have one person who never wants to come to privacy training, who's like, I know everything, I don't need to come to training. Of course, that's the one person who commits all the things later on. But you do need to know, can I make other people come to our training? And if not, don't be the health information custodian for them. Let them be their own custodian because they're not complying with the rules. So in a group, you do have to be mindful of, look, I'm going to be super diligent. I don't know if my colleagues are. Maybe I just want to be a custodian for myself. And then I will leave my colleagues to do their own level of compliance that makes them feel comfortable. Or you can agree, yes, we're all going to do this together. You want to talk about how expenses for privacy will be shared and how you're going to deal with insurance, because there can be benefits to having a group practice for insurance, but you can also get independent insurance for privacy. So that gives you a sense that being a health information custodian is a big deal. There's a lot involved. As one of the handouts for today, I've given you a privacy prescription. It is one of the things you can take away and just go through the list and start checking off, yeah, I have that, we have this. In our group practice, we take care of these things. I just want to share in high level, there's a lot more to each of these items behind the scenes, but I wanted to share with you, here's how you, generally speaking, become compliant as a health information custodian. Again, if this is your responsibility to demonstrate compliance with this law, here are the things you need to do. Number one, you have to choose a privacy contact person. That might be called a privacy officer. I do want to differentiate. I hear this all the time. Well, the privacy officer is the health information custodian. Well, not necessarily. You can choose an administrative person to be your privacy officer. They then do all the tasks of privacy compliance, but you as the owner of the business, you retain the ultimate accountability for compliance. So you might assign that to an admin person, or to one of your partners might be the privacy contact person. It doesn't have to be the human who is the custodian. That person is going to make sure that you have processes for responding to access requests. That's again when a client wants a copy of their own information, or correction requests when the client wants to make a change to their records. But also, someone has to respond when anyone, it could be a member of the public, it could be the media, it could be clients, family members, make a question about your information management practices. What do you do with people's information? Somebody on your team has to be able to and ready to respond. Receiving privacy complaints, and also ensuring overall compliance. So the other 12 of these items. Number two, you do need to make records available to clients. That does include electronic health records that have to be made available in electronic formats. We're seeing a little bit of change in this. I'll explain that in a second. Number three, you do have to have clear rules. Usually those would be in writing. If you're super small, you alone, privacy, you're your own social work, you're a solopreneur, I wouldn't worry about having it in writing. You have to follow the rules. Once you start having staff that are working for you, it does have to be clear to them what your expectations are about privacy. So as you get bigger, more sophisticated, bigger group, you want to have more sophisticated written rules about privacy. Number four, you do have to ensure that all of your agents, and by that I mean agents mean anybody for whom the custodian is, anybody acting for the custodian. So that would be any employee. But also remember, sometimes you might have student placements. When that student is placed in your practice, that person is your agent. They're acting on your behalf. They're in your environment. So you are responsible to make sure they understand privacy in your environment. It might be locum practitioners that you have come in to cover for you, etc. Also researchers. So if you're in an academic practice, researchers are often agents acting on behalf of the custodian. you have to tell them what they're supposed to do. You have to train them. You're supposed to be giving training every year. So that is not a standard in law. That is a standard that has been articulated by our Information and Privacy Commissioner of Ontario. That does not mean you have to take them out of practice and have them do a full day training every year. You have to take privacy out of the box, and every year you have to explain what does privacy mean to them in their work annually. And you need to do annual confidentiality pledges. So every year, get all of your people to sign off, oh yeah, I remember privacy. So when you're doing that confidentiality pledge, it's just a good time to tell them, hey, here's what's new in privacy. Here's something I want to remind you about. And that way you are getting that training component with the privacy confidentiality pledge. Number 5, you have to have a written statement. This does have to be in writing, no matter what size you are, that is available to the public about what you do with information and how you manage that information. There are free resources by the Information Privacy Commissioner. So if you don't have anything in writing yourself, just go to the Privacy Commissioner's website. They have your privacy notices that you can just print up yourself, and anybody asks, look at it, make sure it generally reflects what you do. But it's a hashtag good enough version that if you don't have something yourself, you can use that to share, here's what we do with information in our practice. Now, number 6, we do have to make sure that we are safeguarding information. Oftentimes in privacy, this is the only thing we ever talk about, which is protecting health records. It is a very important foundational component, but you do have to protect records against loss, theft, unauthorized access within the team, unauthorized disclosure, which is sharing information outside the team, unauthorized copying, modification, or disposal. So think about the technical ways you protect health records, the physical, maybe you put records in a room and you lock the door, maybe you have records in a drawer and you lock the drawer, the physical protections that you have, and any administrative safeguards, which would be policies, procedures, training. So again, the Privacy Commissioner has endless resources for you to avail yourselves of to learn about how do I protect the health records I hold. Number 7, you want to make sure anytime that you have to keep records, store records, move records, dispose of records, any of those activities, that you have in place a way to do that securely. There are, 10, 15 decisions of the Privacy Commissioner where that went horribly wrong. Someone thought they were sending their records to shredding, but instead they sold them as scrap paper, and they then got sold to a film company, and health records were raining from the skies in a 9/11 film shoot in downtown Toronto. You cannot make this up. So if you are thinking about, I have all these paper records from years ago. I don't need to keep them anymore. They're beyond the retention period. I can now dispose of them. Or we have all these transitory handwritten notes that we don't need to keep because everything's in the electronic system. Let's dispose of that. You need to have an agreement with a company to shred your records who isn't going to keep those records and sell those as scrap paper. They know they actually have to shred them. So there's an example. Number 8, we have to make sure that anytime you have relationships with vendors, like those storage companies, your electronic health record vendor, anytime you engage someone to act on your behalf, maybe you have a cleaning company or whatever coming into your space, that they understand what you expect of them from privacy. So put that into your vendor agreements. You do need to be performing audits of your electronic health records, your documentation, make sure no one's going in inappropriately. When you bring in new technology into your practice, this is a mouthful. Let's see if I can say it in one go, but you have to make sure that you're complying with digital asset interoperability standards. That is a difficult way of saying, in Ontario, we are trying to have integration in all of the ways health records should be able to connect. Wouldn't it be amazing if we had an integrated healthcare system? Angels would sing. So what we're trying to do since 2021, the government is saying, hey, healthcare providers, if you're going to introduce new tech, that new tech has to meet certain standards. So eventually your record can connect with the rest of the records in the province. So that's just something for you, because that is not intuitive. That's not on your mind. Oh yeah, I'm going to buy new tech. I have to think about what the province thinks about it. But you do. If you're the custodian, you have to be looking at these standards, making sure your tech will work with the provincial expectations. Final couple of things. When you do have a breach, and by the way, eventually everybody has a breach. You do not have to be perfect in this world. You may have a privacy breach over the time. When you do have a privacy breach, you have to be transparent. You do have to tell impacted people that their records have been compromised. You do have to report that to the privacy commissioner. There's annual expectations of reporting if you've had a breach. And then there are in-the-moment reports that are required. I'll explain that at the end. And you also want to think about insurance. Some of you, any of you who are your own custodian, you may have noticed that over the last 6 or 7 years, we've had a real swing upward in complexity of the environment for compliance with privacy. So we now have annual statistical reporting and in-the-moment reporting of certain kinds of privacy breaches. In 2020, yes, in the pandemic, there were increases of fines for very serious privacy breaches to $200,000 for individuals and up to $1 million for businesses. There also now can be jail time. No business has ever been fined. No one has ever gone to jail, but we have had 5 people prosecuted in Ontario. And in fact, the highest prosecution involved a social worker. She looked at the records of 139 people. She worked in a family health team. She was not providing care to any of them. She was a student at that family health team. When she was brought on, she was told, here's what you can look at, and here are the records that you can review. She knew people in the community. She reviewed their records, 139 people. She was personally fined $25,000 for violating people's privacy. So there's an example of fines. Those new interoperability standards I mentioned. There are new additional auditing requirements. There are expectations of how you give access if you've got electronic records. We also now have these amazing organizations, and sorry, they're not organizations, they're groups called Ontario Health Teams. You may have heard of them. So all over the province, we're now trying to organize how we deliver healthcare in these new communities or supporting these communities. And you might want to know, how do we share information in that environment? Also, some new rules about working from home, virtual care, etc. So lots of compliance piece. And so that really is the summary of what you have to do if you're a health information custodian. Okay, we're moving along to the circle of care. Mythology abounds. So what is this thing called the circle of care? It is just a term of art. If you looked at the legislation, you will not find the words circle of care. They do not exist. The idea is that in healthcare, back in 2004, the law was amended to allow, if you're providing healthcare, you can share information with other healthcare providers relying on implied consent. You didn't have to go to your client and ask first. You can share information to deliver healthcare. So I would consider the circle of care on a spectrum with a lockbox. The circle of care, you're allowed to assume that your client wants you to share information with their other healthcare providers to give them healthcare. That's the circle of care. On the other side of that spectrum is when a client proactively tells you, I do not want you telling my family doctor. I do not want you telling my psychiatrist. Don't share my information. That is a consent directive or a lockbox. You cannot assume implied consent because your client has actively told you do not share. So those are two ends of the same spectrum. So let's talk about this circle of care. It has a who and a why. So for you to be able to assume implied consent to share information, the who has to be to another healthcare provider, another health information custodian. Why? To provide healthcare. Not for teaching, not for quality improvement, not for research, to provide healthcare. So the who and the why. So let's look at this list. Who can be in the circle of care? I'll just give you a second to look at the list. So who can be in the circle of care? A school, a hospital, an insurance company, a client's sister, a landlord, police, a primary care team, workplace safety and insurance board, or a children's aid society. So who's in? The hospital and a primary care team can be in the circle of care with you. So you can share information back and forth with them. Who's out? The school is out, but the school board social worker can be in. A client's sister is not in the circle of care. A landlord, police, workplace safety and insurance board, children's aid, or insurance company. That does not mean we'd never provide information to these people. We just cannot assume that our client wants us to do that. So again, if we look at who is a health information custodian, we see the usual suspects, including you, who's in the circle of care. As long as you provide health care. So back to that original conversation, if you're only working for children's aid societies, you're not in the circle of care. If you're only working in a prison or for Ontario Works or ODSP, you're not in the circle of care. But the rest of you are, and you're providing healthcare, you're in the circle of care. And so you're allowed to, and they are allowed to assume that they can share information with you. That does not mean they always do. So you may have some questions, and I'm happy to answer. What do you do when a hospital will not assume implied consent when you work in a school board and you're a social worker? I hear this all the time. So the circle of care doesn't mean that the other groups must share information with you relying on implied consent. It's just that they may. And I would say we as a whole system have to do better relying on implied consent because this moves things forward. So who's not in the circle of care? All those people we talked about at the beginning who are not health information custodians. We can share information with them if we have express consent, that is verbal consent or written consent, or if we're required by law or permitted by law to disclose. So how do you know? You can assume it. Please share, please. We as a healthcare team, healthcare environment, we have to do better at sharing information. Back in 2004, I remember, because I was there when the legislation was being introduced, a lot of people in the mental health system said, I don't know, I don't think our clients are going to get this implied consent business. We should postpone relying on implied consent for 6 months. It's been 20 years. So we do need to assume implied consent. We need to assume that we are going to share information unless we know otherwise. So if a client says they don't want you sharing information, then you can't. So the circle of care is not no consent. If you know your client doesn't want information shared with their other team members, or if when someone is admitted to hospital, they don't want information shared with the social worker back in the school board or at their family health team, then that information will not flow. But that's not really what's happening most of the time. Most of the time, things are just falling through the cracks because we're just not a great system and we're not proactively sharing information. So if you do have a situation where a client says, I don't want information shared, then in order to share going forward, you would need express consent. That, again, is verbal consent that you document, or you give them a form that they complete, and then you can share. This whole circle of care is what underpins the effectiveness of Ontario health teams. We're absolutely allowed to assume implied consent to share information. And mature Ontario health team status is when we have integrated health records and client portals where they can see their own health journey. That's where we're moving to as kind of a future state. We have made it to the most controversial of subjects. So let's talk about privacy and kids. Now, the first thing I want to say is that there is no magic age when children pop up, all of a sudden they're able to make their own privacy decisions. And most clinicians and most parents think there is a magic age, and there isn't. So this means we have to look at each kid. Is that frustrating? Yeah. Is it confusing? Sure is. Does this create, Differences, absolutely. But that's the rule, and so we have to go with it. This is why we're good at nuance in social work practice, right? It's because we're dealing with differences. Each person is their own person. We have to decide, are they capable of making their own decision? So the test that you're applying to your youth client is, do they have capacity? So we presume everybody's capable in healthcare. Everybody's capable, unless it's unreasonable. Someone who's unconscious, they're not capable, they're unconscious. Babies, we're not like, oh, are you one of those smart babies? No, they're not capable. The difficulty you have, especially when you're serving youth, are those ages 10 to 16. Now, in my practice, I've been doing this for 25 years. I don't have situations where clients have found children under the age of 10 to be capable. It just hasn't come up in my practice. It could be, I'm willing to hear that, but most of the time under the age of 10, children are not able to make their own decisions. Most of the time in my practice, children over the age of 16, it's not controversial. They are, unless they have an intellectual limitation or a developmental limitation. And there will be some people who never attain capacity because they will never be able to meet this test. So for you, I find practically it's the kids between 10 and 15 or 16 that you're assessing. I have lots of 10-year-olds making counseling decisions, lots of 11-year-olds making counseling decisions. So the test is to be capable, you have to be able to understand the information about the service or about the privacy decision, and you must be able to understand the reasonably foreseeable consequences of saying yes or no to the service or to the privacy decision. Practically speaking, this means intellectual ability and maturity, or a developmental skill, that you can put a decision in a context and the person has the ability to reason it through. So when you're making counseling decisions, that's going to be a lower threshold than making psychiatric medication decisions or decisions that are about palliative care. That's just going to be a higher intellectual standard. But a lot of counseling does not require a lot of intellectual capacity, frankly. Are you going to come? Do you understand that you're going to come and speak to someone? Do you understand that we're going to discuss your how you're feeling, what you're doing, how your parents, what's going on with your parents or what's happening at school? That is most of the time a lower threshold than some of these other healthcare decisions that get made. So we do find that social workers and social service workers will have capable clients in the 10, 11, 12, 13 range, right? That some other service providers won't have. And you can be capable of making some of your own decisions and not all of your own decisions. Does that make it complicated? Sure does, right? So these families that may be going into other environments, they may be having to choose for their child, but when they're working with a social worker, the social worker assessing this test may find that the individual is capable. So that is a you decision. Who consents then is a capable client of any age, makes their own decisions. If someone is incapable, they need a substitute decision maker. If your client has died, there is still someone who makes decisions. If the client had a will, so this would have been an adult, if they had a will, it's the person named in the will as their executor who would make decisions about the information that you hold. If there wasn't a will, and lots of Ontarians don't have a will, public service announcement, please go make yourself a will, then it is the person who's taken over dealing with the body, dealing with any of the property, dealing with the estate. Now, here's why people think it's at age 16. You'll hear this all the time. Well, kids over the age 16 can make decisions. Kid under the age of 16, their parents make decisions. Here's why. Stay with me. If you have a capable client who is under the age of 16, their parents can also make privacy decisions for them unless the information related to treatment or counseling the child decided on their own. But if a capable child says, I don't want my parents involved, then the capable child's decision overrides. I'm going to go through some scenarios because this is hard to get our head around. So in the slides and in the handouts, I've just kind of given you a summary of who can make decisions and when, but let's go through some scenarios. Now, you have a 13-year-old client. You have decided that they are capable of making their own decisions. So when they come to see you, the child is making their own decisions. But the parent now wants copies of records from when the client was 9, when the parents were making decisions for the child. So can the child consent to the release of that information? Yeah, the child is capable. Can the parents? They can, because the parents are asking for records from when the child was 9 and not making their own decisions. So the parents can also decide about the release of that information. But as soon as that client turns 16, then that convenience for the parents goes away. And that's why people think it's age 16, but actually it's more nuanced than that. Let's go through another one. Now you have an 8-year-old client who's incapable of making their own decisions. The parents want a copy of your records to get a second opinion. And maybe they're even mad at you. They might sue you. So who can consent? Can the child? No, the child's incapable. They can't consent. Can the parents consent? Yes. And even if they want the records because they're mad at you, they would be the substitute decision makers. They would be allowed to have access to the records. So it doesn't matter why they want them. They can have your records as the substitute decision makers. Now here's the last one. You have a 15-year-old client who has received services on their own. The parents want a copy of your record to send to their insurance company so that they can be reimbursed for the services. Can the child consent? Yeah, the child's capable. Can the parents consent? No, because they're asking for a copy of records for which the child made their own decisions. So then you would have to go to the 15-year-old and ask for permission to share. So that is why all of these things are nuanced. So parental disputes. I know this is something that happens for many of you. If you have a capable child and their parents disagree about privacy decisions, the capable child can give you instructions. So we don't have to ask the parents. The capable child can give you instructions. The real problem is when you're dealing with incapable children. So for incapable children, if there are 2 parents, then the parents together make decisions about treatment or service or counseling and privacy, unless that right has been removed from one or both of them. How would you know? There's a document for that. So if someone is in Children's Aid Society care and custody, there will be a document for that. If there has been a separation and one parent has custodial rights and one parent has access rights, or if there is a criminal circumstance and the parent has no right of a contact with their child, there'll be a document for that. And so someone has to show it to you. So who can be a substitute decision maker is a list. It's the same list in privacy as it is in treatment. And so we start at the top at number 1. It's a prioritized list. On the left side is a legal process. Someone had to do something to get that authority. To become a guardian of the person, someone had to go to court. 2, an attorney for personal care or property, someone had to write that. Children can't write those documents. So children cannot have a POA. You'll hear that language. Can't have a POA. Only adults can execute that. Number 3, someone who's gone to the Consent and Capacity Board. That is a big deal. You can go to the Consent and Capacity Board and become a personal representative. Most people don't know that, so that's very rare that you will see that. From 4 to 8, these are the automatic group. So no one has to do anything. These people automatically make decisions, a spouse or partner of the client. Now here's where, if we're dealing with kids, the parents pop up. So parents are at number 5. But it says in the law, if a parent has custody, they outrank a number 6, access rights, only parent. So that's why you need to see the separation agreement. Then it would be a brother or sister who's over the age of 16. And then we're looking for a warm body. Any other relative. This might be a grandparent. It might be an aunt or an uncle. Any other relative. If there isn't anyone, then the decision-making goes to the public guardian and trustee. Note on this list is not a roommate. It is not a nice person from the community. It is not a friend unless that person has had a legal process where they were identified. So if you're talking about separated parents and those separated parents are like, I don't want you sharing information with the other person, you need to see something in writing, a court order or a separation agreement approved by the court. Now, some of you may ask, am I supposed to canvass all parties? Well, the Privacy Commissioner has answered that for you. So there was a case where there were two parents. One was a dad and one was a mom, and both had custody. The mom came forward to the agency and proactively said, don't tell my ex-husband anything about our children. So she proactively gave an instruction to the health center, don't share information. The dad, unbeknownst to him that his ex-wife had done this, came to the health center and said, I would like a copy of my children's information. But the children were not capable. They were very young. So these parents were their substitute decision makers. The problem was because the mom had proactively told the agency, don't share any information with him, they could not. And this went to the Privacy Commissioner, and the Commissioner said, that's correct. Although both of you have decision-making power, if one of you proactively says the other can't have it, then we cannot give information to the other. Now, this disintegrates very quickly because you can imagine then that the ex-husband is now going to proactively say, fine, now my ex-wife can't have it. And now this becomes silly. So sometimes we have to cajole people into behaving appropriately in the interests of their children. But sometimes this will have to go to court in their family law experience to sort it out. You may not be involved. So then your question is, do I have to ask them both? And the commissioner said no. So you do not. So you have these two parents and you're seeing their kid and everything's tickety-boo and they've come forward and the kid's being seen and neither one of them says anything about sharing information. And one of them asks for a copy of the record. You can give it to them. Do you have to tell the other? No. When the other comes forward and asks for a copy of the record, can you give it to them? Yeah, you can give it to them. Do you have to tell the other? No. Do you have to make 2 copies? No. Now, you might proactively want to do this, and you may want to have a conversation with the family of here's how we're going to share information. And maybe you even say, I'm not giving you copies. Let's just say I'm going to give you summaries. Then you can kind of nip this in the bud early. The problem is if either one of them says, don't share information with the other, now you have a proactive instruction and you can't give any information. Often, again, this will result in them going to court. I know you will have questions. I'm happy to answer them in the question period. 2 more quick things. I do want to tell you about how to limit confidentiality. This is where you are permitted or required by law to share a client's information without their permission. For the most part, the umbrella categories of where we're allowed to do this is to have safe, protective environments and to have a functioning healthcare system. So these overrides to privacy apply in those circumstances. So you're allowed, being permitted by law, you don't have to do it. You're allowed to do it. It's where another law says you as a social worker or a social service worker are allowed to share information without the consent of the client. For example, you can do that for teaching within your team. You can do it for research purposes if a research ethics board has approved. That's permitted. You don't have to do those activities, but you're allowed to do them without the consent of the client. What we want to focus on is where you are required by law to act. So sometimes a law or a legal instrument says you have to collect, that's take in information, use it within the team, or disclose it outside the team. You're required to do that. So when you're required to do it, you do not get the client's permission. So for example, that will apply when you have a child in need of protection. You have to report that someone is at risk of or has been physically, emotionally, sexually abused, mandatory reporting. Public health concerns, communicable diseases have to be shared. Transportation safety. This doesn't really apply to you, but for nurses and doctors and optometrists, they have to report if someone is unfit to drive. regulatory colleges. So there will be circumstances where if you're being reviewed by the college can come into your practice, review your notes. That's not, oh, I guess I have to ask my client. No, you must share that information with the college. The coroner, when someone dies, the coroner can come in and ask for certain information. And also, Workplace Safety and Insurance Board have circumstances where you must share information with them. In those situations, if an authority is telling you that you are required by law to share, you should ask them to put that in writing for you. You're also required by instruments such as court orders, summons to witness, subpoenas, warrants, and urgent demands for records. That's when someone is a missing person. That's new as of 2019. If you get any of these things in writing, sometimes you're going to need legal advice, but just read the document. You may be required by law to share information. All right, just to wrap this up, what is a privacy breach? I just want to share this with you. There are things that you have to protect. You have to protect your client records from loss, theft, unauthorized use within your team, unauthorized disclosure to someone outside your team, unauthorized modification, that's a change to the record, or destruction. If any of these things happen, you have a privacy breach. You must notify impacted clients, and in certain circumstances, you must notify the Privacy Commissioner of Ontario. So we have all kinds of different categories. Sometimes we only think of privacy breaches as like the big scary things like cyber threats, but there are lots of ways in which we have to protect records. So when you have a privacy breach, there is a mandatory report to the Privacy Commissioner, and the Privacy Commissioner tells you what to do. So don't worry. You just go to their website. You have this potential consequences of a breach under PHIPAA, what to do when faced with a privacy breach. And they give you instructions what to do. So they have a 4-step plan. You follow the plan, and you read their document. There are things you do have to report to the commissioner. There's annual reporting and there's in-the-moment reporting. For the annual report, you only have to report if you're a custodian. If you're an agent, your workplace will report. You don't have to report. So if you're your own custodian, this applies to you. And you only have to report if you've had a privacy breach in these categories in the last calendar year. So if you had a privacy breach the year before, you don't have to report year over year, only when you've had a hit in these categories. If you've had information that was stolen, information that was lost, information that was used without authority, information that was disclosed without authority, highlight misdirected faxes, and times information was collected without authority. So why do I highlight the misdirected faxes? We've been reporting since 2019. Every single year, the misdirected fax category is the highest category of reported breaches. So about 10,000 breaches reported to the Privacy Commissioner in 2022. Of those, there were almost 4,000 misdirected faxes. So the Privacy Commissioner has lots of thoughts about sharing information by fax. You do also have to report to the Commissioner if you have a case of someone snooping in records, if information has been stolen, health information, if someone is threatening to go public with health information from your record, if you've had a pattern of breaches where you've got a new electronic fax system and it just randomly faxes a whole bunch of people and there's a pattern to that, you would have to report that to the Commissioner. If you have taken disciplinary action, or if the custodian has for an employee who's regulated, or even an employee who's unregulated, and there's been disciplinary action, that has to be reported to the Commissioner. And then there's a bucket of anything else that was significant. So a lot of people impacted, highly sensitive information impacted, a lot of custodians impacted, has to be reported. That was my whirlwind tour of privacy and the key considerations for health information custodians. I think we have 10, 11 minutes left for questions. So I just wondered if there was anything that has been put in the chat.
Perfect. Thanks so much, Kate, for that. We do have some time now for questions. Attendees can enter their questions through the chat feature on the right-hand side of their screen. A reminder that the chat feature is only available for those accessing the session on a computer or laptop and not from a phone or tablet. So you spoke to this early on with regards to who is and who isn't a health information custodian and who is an agent. So we received some questions throughout the presentation with regards to this. So perhaps you can reiterate for us, for example, for social workers and social service workers working in a post-secondary health and wellness center, or housing support workers, or those working in a shelter.
Great. It depends. Isn't that a good legal answer? So what does it depend on? It depends if your focus is on the mental health or the physical health and welfare, or if you're helping shepherd someone through a system. So when you're not working for a traditional healthcare provider like a hospital or a family health team, you do have to use your discretion. And it really is good for you to talk to your employer. Like, hey, are we a health information custodian or not? But I think the crux of the question, if you're in a shelter, if your focus is, sometimes people in shelters are helping people navigate through the justice system. That's not providing health care. Now, it ultimately might help someone in their health journey, but that focus isn't healthcare, it's on a justice journey. If instead your focus in a shelter is to help someone through their mental health journey and you're doing counseling, I would say that is healthcare and you're probably a health information custodian. So in a post-secondary institution and you're at a wellness clinic. So the wellness clinic makes me start to think it's more healthcare, right? But if you're in a post-secondary institution and you're supporting someone through what courses to take, or how do I balance my stress levels in this environment? How do I deal with racism in the school? How am I dealing with, there are all kinds of things going on in the world these days. And I'm really struggling with, how do I advocate for myself? That's more, that's not healthcare so much, unless you're if you're doing real counseling, if you're providing information, system navigation can be healthcare, but that's mostly when you're working for a traditional healthcare environment. So I hope that helps some of those questions.
Yeah, I'm sure. Along those same lines, actually, are you providing healthcare if you are not assessing clients directly, but supervising or managing a group of clinicians that do?
Yeah, that's a great question. You're not providing healthcare, but your organization is providing healthcare. So supervisors are absolutely allowed to go into health records to oversee or supervise a health service. So for example, in a school board, you will have social workers delivering and having assessments and doing one-on-one service. And then their supervisors are allowed to go into health records to make sure that those social workers are doing the right service. So if that's the question, you're not providing healthcare, but as a team, healthcare is being provided, so you are supervising that health service. So that's when you might have a need to go into health records or talk with the social worker that you're supervising, or the student that you're overseeing. What are you thinking about? How are you navigating this? That's all perfectly legitimate activity with no consent of the client.
Great, thanks. Another question here. How does consultation work with someone who is not part of the circle care? Mm-hmm. For example, a social worker speaking with a psychologist for consultation in relation to a client in a hospital setting where there is interprofessional collaboration. Is that okay? Or does there need to be an agreement in place?
Oh, great. Okay, so consultations are care, right? So when you are consulting with another healthcare provider, so social workers like, you know what, this client is hard. I'm going to talk to my other colleague because I know they deal with this particular kind of circumstance or condition. And the colleague is a psychologist. That is a clinical consultation. That is all done without consent of the client it kind of depends. If you're asking for mentorship, that's done without the consent of the client. If you're doing a consultation and the psychologist is getting the backstory and that person might even become a client of that psychologist, that is a circle of care relationship. So that's usually done with implied consent. Usually you will tell the client, I'm going to do a consultation. I'm going to ask my colleague who deals with clients just like you, I'm going to ask her about this, and then you're going to share information. If you're doing it on a no-names basis, hey, I've got this client and they're 52 and they've got these circumstances, that's done anonymously, that's not sharing personal health information, then the whole legislation doesn't apply. So that is also permitted. What I would caution you is, here's the rub, just taking someone's name off information does not de-identify it. If there are enough markers that you would be able to link that information to a person that's not de-identified, so you are sharing personal health information. But if you're just talking about a composite, you're talking to a colleague like, oh, I always struggle with these kinds of clients, that is generally anonymous. That's all outside the law. And that is, you should be doing that. We want people to get supports for their practice and their clinical development.
Great. Kind of on a related note to consent there, related to sharing information and consent, how do you know if a client doesn't want you to share information with a health information custodian? Is it only if they bring it up themselves, as you mentioned, or are you expected to ask first? And in what circumstances is written consent to share information recommended over verbal consent?
Okay, great. Okay, so the circle of care, this is hard, I'm going to push you, okay? So the circle of care, you can assume it. You can assume it. We really should be sharing information with each other in healthcare. So many people are falling through the cracks in the system because all the people who are supposed to be supporting them are not talking to each other. So how do you know? You're allowed to assume it. Now, what might the circumstances be where you would ask first? You have a relationship that you have struggled to forge, and it's fragile. And you're like, I don't want to do anything that might compromise my hard-won relationship. In that case, you might overdo it with the express consent so that you keep that forged relationship because it was new. Another circumstance, someone is highly suspicious. So in dealing with the client, they've never expressly told you they don't want any information shared, but in dealing with them, you know that they're a very private person. They haven't said it out loud, but you know full well that if you shared information, they would be upset. So if in your clinical judgment, this is the kind of client that you would have that is highly private, don't push it. So ask them explicitly. So then the second part of the question was, how do I know about written consent and verbal consent? Verbal consent is legally equal to written consent. Okay, so someone gives you verbal consent to do something. When it's verbal, express consent must be written down, whether it's in a form or someone gives you verbal consent. If they give you verbal, you have to write it down, or your office has to have that recorded in some way. A form isn't the only way we get consent. A form is lovely. I'm a lawyer. I love a form. They keep me warm at night. I could snuggle a form. But forms are just one convenient way we get consent. Verbal consent is a way that we can be really respectful to clients. It doesn't put as much burden in front of a client sometimes to come in, sign the form, do the thing. So when might you not rely on verbal consent? Again, if you have someone who changes their mind. We all have these clients. I never said this. I didn't give you permission. That is not the client I'm doing verbal consent with. I'm going to get them to put it in writing because when they say, I didn't give you consent, yes, Kate, you did. Remember when you signed this? Oh, yeah, you're right. Fine. So those kinds of clients who change their mind, I'm going to rely on a more formal process. But you can rely on verbal consent. And then if they do change their mind in the future, you can go more formal going forward. Also, you do need to follow your organizational rules. So this is also decided by your organization. So if they have forms that you need to fill out, don't just say, oh, there's this lawyer that I listened to one day. She has red hair. She said I don't need to use a form. No, you have to use the organizational documentation expectations. So those are some ideas.
Fantastic. That's so great, Kate. I think that's about all the time we have for questions. But thank you so much for such a dynamic yet practical presentation. You really made a topic that can be challenging to navigate, easy to digest, and very engaging. So Thank you so much for sharing. As a token of our appreciation, the college has made a donation to the Indigenous Women's Fund of Canada. Thanks again for participating in this year's Ahmed.
Thank you. Thank you, everyone.